Welcome to my channel. Please like, comment, and subscribe. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law's roots can be traced back to the unwritten customs of nautical behaviors of the Egyptians and Greeks. However, the earliest formal codes were established around 900 before Christ on a Greek island of Rhodes. The original maritime laws and codes stemmed from the ancient customs and rules of shipping. For examples, the doctrine of general average, the concept of that all sea cargo stakeholders, owners, ships, and etc., evenly share any damage or losses that may occur as a result of a voluntary sacrifice of part of the vessel or cargo to save the whole, can be traced back to the early shipping customs of the Rhodians. The concept of spared legal authority regulating maritime issues was brought to the West by Eleanor of Aquitaine, who learned of the concept when she accompanied her first husband, King Louis VII of France, to the Mediterranean on a second crusade. The term admiralty law comes from the British Admiralty courts, who presided over maritime matters separately from England's common law courts. As the U.S. judicial system is based on a British system, amended admiralty law were gradually incorporated into our legal system soon after the Constitution was ratified. When does maritime law apply? Perhaps most obviously, maritime law applies to events that occur on high seas. In other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial sea, which are waters within 12 miles of the shore. However, the law applicability becomes less clear further inland. Early in the United States history, maritime law did not apply to incidents that occur within the body of the country, and therefore excluded incidents involving the Great Lakes and non-tidal inland waterways. However, throughout the 19th century, this exclusion eroded away. Maritime law is now applied to navigable waters. A waterway is deemed navigable if by itself or by uniting with other waters. It can serve as a continued highway over which commerce is or may be carried on with other states or foreign countries. Consequently, if a body of water is completely landlocked with a single state, that it is not navigable for purposes of admiralty jurisdiction. However, a body of water does not need to flow between states to be deemed navigable. A body of water may be deemed navigable if it is lying in a chain of body of water that can be used to service interstate commerce. Ultimately, the task is that the commerce of one state must be capable of being carried into another state or a foreign country. Once this task has been passed, it is likely that maritime law will be applicable even if it is a recreational vessel. Incidents that require Texas maritime accident attorneys. Houston maritime injury attorneys exist to help injured seamen or dock workers to get a compensation they need to recover from serious injuries and afford long-term medical costs that occurred offshore. That includes any accidents that occur on navigable waters, rivers and oceans, and in harbor or docks. All maritime lawyers have represented clients who were injured in jacob rig accidents, tugboat and barge accidents, deck accidents, commercial fishing accidents, fall overboards, cargo ship accidents, dredge accidents, our platform accidents, shipyard accident, cruise ship accident. One notable aspect of a maritime accident that is there often devastating, offshore oil rig explosion cause significant damages. Vessel collisions are frequently catastrophic, and oil platform can unfairly change the lives of workers. Maritime lawyers fight to help workers recover the compensation they deserve, whether they are suffering after a major explosion or have injuries caused by unsafe working conditions. Our maritime attorneys represented more crew members of the Deepwater Horizon and the Elfaro than any other law firm. We not only understand maritime law but the practices and culture of maritime employers. Speak with us to discuss your case so we can go over your legal and financial option. The basic of a maritime law. Maritime law is derived from any sources, federal statutes and general maritime law being two of the most prominent. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and the passengers and crew. Maritime law sets forth many of the basic legal tenets associated with the sea and a seaman, including seaman's right to maintenance and cure. Maintenance and cure are benefits that an injured seaman receive from any employer during the course of recovery. Maintenance includes such expenses as a seaman rent or mortgage, utilities, property taxes, homeowners insurance, and food. Cure is similar to workers' compensation benefits for land-based employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is a captain or a crew member aboard a vessel in a navigation. Also similar to workers' compensation, maintenance and cure does not require the seaman prove any fault for the injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen a statutory right to sue the employer for personal injury damages. However, a seaman must spend at least 30% of the time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seaman a statutory right to sue their employer, it also is the burden of proof needed to prove cautions between the employer's negligence and the seaman's injury. Under the Jones Act, the employer negligence only needs to play a part in a seaman's injury rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in a state court under the Jones Act are not removable to federal courts. And then there is the Death on a High Seas Act. When the death of an individual is caused by a wrongful act or neglect occurring on a high seas, the Death on a High Seas Act guarantees that a personal representative of the descendants can bring a claim. The Saving to Suitors Clause. Federal law establishes exclusive jurisdiction for admiralty and maritime cases in a federal district. Courts absent any language indicating the contrary within a statutory created right, such as the Jones Act. However, the Saving to Suitors clause refers as non-admiralty remedies that may be available to an individual. An example of an admiralty remedy is a suit in which the claim is brought against the ship. And the Longshore and Harbour Workers' Compensation Act is the next. Federal law created a certain statutory right for employees who are not necessarily seamen but nonetheless work on harbor or vessels that are under repair or being built. This law covers longshore workers, ship repairers, shipbuilders or shipwreckers, and harbor construction workers. Moreover, the injuries must occur on navigable waters or an adjoining area such as dock. This law provides for the payment of the compensation and medical care for an injury injured while on the job or surviving benefits. And then the Outer Continental Shelf Lands Act extended Longshore and Harbour Workers' Compensation Act to employees engaged in offshore drilling on outer continental shelf. Jurisdiction in maritime law cases. In the U.S., jurisdiction over admiralty law matters were originally given to federal courts. However, today most admiralty cases can be heard by both state and federal courts under the Saving to Suitors Clause in Title 28 of the United States Code. The exception to this is any matter involving maritime property. Those cases may only be tried in federal courts if a state court presides over an admiralty case. The court is required to apply admiralty or marine law rather than its state law. And then how does maritime law provide for hard workers? Without maritime law, injured seamen would be left on their own to be counteract the suffering they sustain while working. Anytime a ship employee becomes injured or sick, the vessel owner is required to reimburse the losses. Maritime law refers to this reimbursement as maintenance and cure, meaning that until the seaman fully recovers, the employees must provide for the affliction. The court views the obligation as an unquestionable duty that a ship owner owes any seaman aboard the vessel. Seamen are also eligible to recover full wages for the length of the voyage during which they sustain injuries or illness. An employment contract may dictate the amount of unearned wages a seaman can receive. I think that's all guys, the information that I can share to you. Thank you so much guys for watching, and if you need information related to maritime topics, you are in the right channel, because in this channel we talk about it a lot. And then if you guys want us to talk about or discuss about information that you like about maritime topics, you can also drop your question in the comment section guys, and later when we have a chance we'll talk about it. And then don't forget to share this video to your friends, family, and your loved one. Maybe then information related to maritime topics. When you share the video to them, it means you already help them to get to the problems. Thank you so much guys for watching. Don't forget to give a like, comment, and subscribe. Bye bye guys, see you in another video.